April 11, 2016. Charlotte Hay. By email, legal.admin@justice.government.nz. Greetings Charlotte Hay. Your letter dated April 8, 2016 and its multiple errors. I refer to your letter sent via email from yourself Charlotte dated April 8, 2016 to myself, in which you have made multiple errors. I am left somewhat curious as to why legal counsel has had my email referred to them or is even involved with what I believe to be a few simple clerical questions. To be crystal clear, at no time have I asked for your legal advice, nor do I require it. I shall address your errors on a point-by-point basis. 1. Firstly, you state your claim for payments of costs in your case. What claim? And you are aware it was not my case. To my knowledge the police was the plaintiff, and it was their case and/or allegations, not mine. Your first error. 2. You state I have made a request for reimbursement for expenses. This is an error on your part. Clearly nowhere in my email dated February 8, 2016 have I made such a request. I am simply requiring a postal address and addressee to send an invoice to Ministry of Justice. Why has this been referred to your office? 3. You stated I understand that on January 29, 2015 you were charged with exceeding the applicable speed limit by more than 50 km per hour and failing to produce driver license. From where have you derived this understanding from? As the two allegations were from an interaction on the November 21, 2014, where did you pull that date from? As well as your elaboration of the allegation of doing more than 50 km per hour over a prescribed speed limit, when in fact the allegation was for doing 25 km per hour over the limit, i.e. 75 km per hour in a 50 km per hour area. Multiple errors in just that one point. 4. Further in point 2 of yours, you stated without the permission or knowledge of the court, you covertly filmed the proceedings. More errors. Carl Luenz, North Shore District Court Services Manager, was given notification that I would be recording the proceedings both verbally and via email prior to the preliminary and defendant hearings. I believe I did not require permission. As for the covered point, my camera was clearly visible in my shirt pocket, and I had given prior notice I would be doing so, along with being a party to the proceedings and having a right to keep a record of the matter at hand. I am aware that covered means to be hidden. I hid nothing. I will point out that congratulations are in order as you did get the preliminary hearing date right. Well done, at least one fact correct, so far. 5. Within your next point, 3. You state following your first appearance, another error, the court staff were well aware that I was and continued to record them prior to my first appearance. I have Carl on video stating this should you need this fact verified. As they are all public servants, acting in public positions in a public building, all of which I confirmed with Carl, there was absolutely no expectation of privacy. Or was there something covert going on they were afraid to be caught on camera? I set Carl straight on this during one of our many recorded conversations. 6. Continuing on your point, 3, another error, as the defendant hearing was held on the May 19, 2015, and not Sunday the May 17 as you stated. 7. As the man, upon multiple times asked, failed to identify himself, and I had tried daily, for the week prior to the preliminary hearing to ascertain the names of the presiding justices, I had no idea of the identity of Selwyn Hayworth until the May 21, 2015, when Carl Luenz finally informed me as to their identities via an email while I was requiring the transcripts of the matter. 8. As Selwyn refused to identify himself, nor sign the acknowledgement he had authored and forced me to sign, denying myself the opportunity to have the document reviewed legally, and using a threat of contempt of court to coerce my signature, I had no idea who he was. 9. The $25 removal fee was incurred the moment the man, who turned out to be Selwyn Hayworth, uttered it. While acting as a judicial officer, I believe he had jurisdiction over infringement offenses, however he had no jurisdiction over my property, namely my videos, nor my YouTube channel. 10. I do not understand the Costs in Criminal Cases Act 1967, I am not legally trained, nor do I understand any legislature, I am not trained to. Therefore are you offering me legal advice? 11. As to why Selwyn has referred a letter addressed to him, individually, to your office, I have no idea. Do you represent Selwyn Hayworth? Is he your client? What business is it of the MOJ? Is Selwyn using a public office and its resources for a private matter? 12. As for the suggested virtue of Section 4B of the Justices of the Peace Act 1957, which I thank you again for your legal but unwanted advice, Selwyn was not acting within the scope of his authority, he ignored my questions of jurisdiction, and had none over myself. So according to your own statement, Selwyn did act without jurisdiction with regards to the removal order, and as such has been invoiced individually for this. 13. Last I checked he was a man, although a spineless one, equal to myself, he ordered, he pays. In conclusion, due to your complete incompetence in getting any of the facts correct, your assessment of the claim I shall be filing in disputes tribunal is dismissed accordingly. As for its merit, I will have my day in court with regards to this matter. Your opinion is unwanted, ignorant, and without merit, not my claim. As for the disclaimer in regards to confidentiality attached to your email, I do not understand it. Everything is posted on multiple public forums, notice of this has been given multiple times. Your correspondence along with a covering letter and video will be posted just like everything else. I have since obtained a postal address, and name to invoice when I wish to. As for Selwyn, I will see him in disputes tribunal should he develop a backbone. I shall forward a link once done for your viewing pleasure. I wish you a great day. Be well. Mark.